Let's Win family. Thank you guys for joining in tonight. I'm excited as this is a topic that we have been discussing quite a bit here in the Let's Win financial community. And man, it's something that's for us that's been crippling us. Just kind of looking at the stats and surveys tonight as we discuss estate planning. You guys know I talk about this quite a bit in a lot of our emails, in a lot of our social media platforms. We talk about estate planning itself here. And so tonight, guys, we have a very, very special guest that's joining us here tonight that I've been working and privileged to work with for well over several years now. I want to say, Giovanni, probably 4+ years now, man, as far as you've been coming over to the Let's Win financial community. And so, with that said, every year you come to us, give us great knowledge, give us great advice, and so a lot of the Let's Win financial members have been able to capitalize on your expertise when it comes to estate planning and being able to set up their own personal trust. One of the members from Let's Win financial community, we learned that live right down the road from you, and you were able to go to her house and set up her estate planning, Miss Donna Arnie and herself here. So, man, what you're doing here for the Let's Win financial community and what you've set up for the members, and I would just like to say this right here, Attorney Borges, even for me, just setting up not only my own family estate planning, but for my parents, and securing our family financial legacy, man. We just want to thank you for your expertise. I gotta say this, guys. When it comes to attorneys, they speak a lot of high level information, but I got attracted to Attorney Borges because I just called him out the blue one day looking for another attorney in particular. I wound up speaking to him. And we had a very interesting dialogue. And normally, when you hear from an attorney, this language is like well above your head. But he was able to break things down to me, and ever since then, I've been connected to him. And so I'm just grateful that he has the opportunity tonight to come and give his expertise. And so when we talk about trust, when we talk about wills, guys, believe it or not, only 32% of Americans have an estate plan. And so we got to look at it and understand and say, if you pass away, if you have young kids, what happens to your 401k? What happens to your house? What happens to your life insurance plans? Things of that nature. Those are the things that we're going to be discussing tonight. And so without further ado, I want to go ahead and introduce our special guest tonight, Attorney Borges here. Attorney, I'm going to open it up here to you, if you don't mind, if you can introduce yourself here to the Let's Win financial community, and we'll get into some dialogue.
Thank you, Sherwin. I appreciate the kind words. I'm actually surprised you remembered our initial phone call, which was like 4 or 5 years ago. But it was a great call. And I see a lot of repeat people here that have come to the past seminars. So it's great to see you guys. I made sure I wore a different color suit this year because I realized I went back on YouTube to watch some of the videos just to see, and I realized I was either wearing the same polo or the same navy blue suit. So I had to break out a different suit for tonight.
You're looking sharp, by the way, man.
Thank you. I appreciate that. But guys, thank you for coming tonight. I know estate planning is not the most exciting thing to discuss. Obviously, it's a little morbid in nature, but the fact that you guys showed up here on a weeknight at 8 o'clock to invest into your education for your legacy and your family's legacy, I can't tell you how important that is and how much further apart you're setting yourself from the average person that has no clue what an estate plan is, wills, trust, or anything like that. And then obviously being able to invest into your financial knowledge with Sherwin and his company is a great decision for you guys as well. So you should all be proud that you're attending here, and you could be doing anything, watching Netflix or watching a movie and wasting your time, but you're choosing to be here and invest in your education and yourself and ultimately your family. So thank you guys for joining us tonight. And I'm, again, happy to answer all questions. I'm going to try to keep it as basic as possible to try to understand it. And Sherwin and I were kind of discussing in past years, I've kind of done more so of a lecture where I've kind of just discussed a lot of things, and we want to just try a different approach this year where Sherwin's going to maybe give me some scenarios and we'll do lots of Q&A as opposed to saving that towards the end so we can be a little more engaging with everyone here.
Absolutely, absolutely. Thank you for that nice introduction, here in itself. So as we talk about estate planning, let's win financial family when it comes to your own personal finances, as far as the hard-earned dollars that you make. We always talk about you make money, but we want to be able to manage it. We want to be able to multiply, and most importantly, we want to be able to protect it through estate planning. So, Attorney Borges, as we get into the session tonight, let's just kind of talk about this in a scenario base here, right? So, if we had a married couple, we got a husband, we have a spouse, and let's say, for instance, they have maybe have a 5-year old and a 10-year old child. If they was to travel on vacation now, and let's say, for instance, they own a house, and in this particular case, they don't necessarily take the kids with them, but they go on a trip for their anniversary. And unfortunately, let's say, for instance, maybe they have a plane accident or they pass away over on this particular vacation, and they don't necessarily have a trust in place. And let's say, for instance, they have a will in place. What happens in this particular case to this particular couple with two kids, with a 5-year old, a 10-year old, and they only have a will in place? What happens in this situation?
In that scenario, we'd obviously have to look at the will to see who it is that their assets are left to. If they left the house to the kids, to another family member, but let's just assume for argument's sake that in the will, something says that if husband and wife or both of us pass, everything is left to our two kids in equal shares. Now, the problem with that is if they pass away and let's say the property is owned by them, but if they both die, now essentially there has to be a new owner. Uh, and we have problems too since the kids are under 18. That's a secondary problem. But what's going to happen is the will will have to go through the probate court, and probate is it's an administration that's filed with the court in front of a judge after someone passes away, and it's essentially determined, or a process to determine what assets the person had when they passed away, whether they have to go through probate or not, and then ultimately did the decedent, who's the name of the person that passed away, did they have a will? Did they not have a will? Because that's going to determine who's entitled to what, and then who the assets are going to. Now, the inconvenient, or the thing that's not good about probate, is generally the estate, whoever it is that's inheriting, has to go and hire a probate attorney. So the average cost of a probate that's filed with the court could be anywhere from 5 to 10 to 15, or even 20 or 20,000 or anything beyond that, depending on the value of the estate. And a secondary problem with probate is that process from the start to finish could take 6 months. It could take a year. It could take 3 years. It could take 10 years. There's a lot of different factors where you may have certain family members that are contesting things. Someone says the will isn't valid, or maybe you have a half child that appears out of the blue from 20 years ago. There's a million different things that can go wrong that can complicate the probate administration, and the family ultimately doesn't receive, or whoever the heirs or beneficiaries are of the estate ultimately don't receive the assets until the probate is completed. So when someone passes away, obviously that's an emotionally difficult thing to happen in life. But financially, if the family is not in a great spot and they need access to these assets for the funeral or for other events, for relocation of the children, whatever it is, the family or the heirs or beneficiaries are not getting access to this until the probate is done. And the third prong to why probate is bad is if the person, the decedent, passed away, if they had any creditors, then the creditors of the deceased party can file claims against the estate. Example, I opened up an Amex credit card 2 weeks ago, and I went on a fancy cruise, and I spent $20,000. I got the unlimited drink package, the food package, VIP, everything. And if I were to pass away and a probate was needed for my estate, Amex can then file a claim against my estate for that $20,000 or any other debt that I had at the time of death. So let's say I had maybe $20,000 in a bank account. That was my only asset when I died, and everything was going to go to my two kids. Now, since what probate is needed, this creditor, Amex, can now file a claim for $20,000 that I owed them before I died, and they can deduct that 20,000 or a large part of it from my assets or from the money in my bank account, and in turn, my children would walk away with nothing. So there's nothing good about probate. And the big, so to recap, a ton of money on attorney's fees and court costs. It can take a very long time, and it also opens the door for creditors. Sherwin, the second prong to that is, if you have children that are under 18 inheriting, that's a different situation. We can kind of probably touch on that when we're discussing the trust. But overall, one of my main goals, and Sherwin's goals when guiding clients is when the time comes and you pass away, we do not want any of your assets to have to go through the probate process. And it's very easy to ensure that your assets don't go through probate. And so that's one of our main goals, and that's what we'll explain today and tell you exactly what you need to do with your assets, whether it's house or bank accounts, stock, retirement account, life insurance policy, etc.
So that's very, very good information there. So can you maybe just give us a basic definition of what's the difference between a trust and a will?
Yes. So a will, the formal name of it is called a last will and testament. And that's the document that says that when a person dies, it basically lays out their last wishes with respect to their assets. For example, if I had a will, it would say my house goes to my wife, my gold watch goes to my best friend, my Lamborghini goes to my favorite financial advisor, Sherwin Riley, right? And so
Yes.
basically, right? So the testator, so the name of person that signs a will is called the testator. They essentially list and distribute or have a list of distribution of where their assets go. Now, a will, common to what people believe is incorrect, but everyone thinks that if they have a will, that solves probate or that avoids probate, and that's wrong. Just because you have a will doesn't mean you get to skip the probate process. The will only comes into effect if there's a probate administration that's required to be filed with the court. So I know it's nice, and we've been encouraged through TV and movies to draft up a will. There's nothing wrong with that. But just because you have a will does not mean your assets will not have to go through probate. A trust, on the other hand, it's a document that's created, and it's almost like a holding entity, but it's not an entity. And so you can transfer documents into the trust, or not documents, excuse me, you can transfer assets that you have, like property, stocks, bank accounts, life insurance policy, crypto. You can have that flow into the trust upon your death. And by those assets going into the trust, this is very important, they do not have to go through probate, which is ultra, ultra important. And there's nothing fancy with the trust. It doesn't have to be 100 pages. There's not a lot of legal requirements. In Florida, the only legal requirements is that the person signing the trust or creating the trust, that person is called the settlor. That's Settlor. That's the person that's creating the trust. The trustee is the person that essentially has legal authority to make decisions on behalf of the trust and to sign documents on behalf of the trust. And then the third party of a trust is the beneficiary. The beneficiary is ultimately the person or persons or entity that's going to receive the assets from the trust. And so the legal requirements, similar to a will in Florida, are that the settlor and the trustee sign the trust. There has to be two witnesses and a notary. The notary cannot be one of the two witnesses, and then the person that's creating the trust, the settlor or the trustee, they cannot be one of the witnesses or one of the notary. So you would essentially need, for example, if Sherwin's creating a trust, he would need three separate people, two to be the witnesses and one to be a notary, to sign off and complete that document.
Awesome. Awesome. So, guys, let me just kind of explain this really quick. So, Attorney Borges set up Let's Find Out Our Family Trust in itself here. And so, for us, we have a 12-year-old, 9-year-old, and 6-year-old. And in this particular trust, what we've been able to do, or Attorney Borges has been able to do, is specifically put language within that trust, right? So, if Leslie and I was to pass away now, we're both 43, and we're able to set up a trustee. Our trustee, our main primary trustee, is Leslie best friend. If Leslie best friend passes away, then we set up what we call as a secondary trustee, which in this particular case will be my sister. So in your trustees, you want to make sure that this is a person that you can trust, that you can verify, that you can validate, to make sure that they will be able to manage those specific instructions, directions that you have in your trust. The trust is more so like kind of still controlling your money, even though that you passed away, you've been able to control this money in itself here. So, Attorney Borges, let me ask you this question here. When we set up the trust, why is it important after setting up the trust that we also put our house in the trust as well?
As it kind of goes back to what I mentioned before, the by putting your house into a trust, it doesn't have to go through probate if you or your joint owner pass away. So that first example that you gave us, where mom and dad pass away and they're survived by two kids, if the house is in the trust, the house does not have to go through probate. The language of the trust would dictate who gets the house or when it's to be sold. And the cool things with trust is that you can I don't want to say you can say whatever you want because that's a very general and broad statement, but you have a lot of liberty to put how your assets are going to be distributed when it's in a trust. For example, if we go back to that example that you said with the mother and father passing and the two kids that were 4 and 5 years old, had they put the property into a trust before they passed away, they can include language that says, my children are not to gain access to the property or any money from the property until they both turn 25 years old or 18 years old or 21 years old, or both children must graduate from a college with a 4-year degree before they're entitled to receive a 50% ownership interest in the house. Alternatively, if you have someone who's acting as a successor trustee, and this is what Sherwin had referenced, generally, most people that create the trust are also going to be the trustees so that they can control the trust when they're alive. It's also good to have one or two successor trustees. And a successor trustee is someone that's essentially acting as a backup. So if one person that's acting as a trustee passes away, you have another friend or family member that then steps into the role as the successor trustee, and they then have to oversee and manage the trust, but it has to be according to what the terms of the trust say. The successor trustee can't come in and just do whatever they want and start cutting out checks and money and selling assets. They have to follow the procedures and what's listed in the trust there.
Absolutely. So let's talk about this here too, right? So we have a lot of young parents on here that may be single, that's not necessarily married. And let's say, for instance, maybe they have their 401k accounts or their IRAs or maybe a life insurance policy to where they have a minor that's under 18 and then they have that minor as a beneficiary on their accounts here. Why is that not a great idea?
It's not a great idea because generally if you have a minor child as a beneficiary on a certain account, or if the minor child inherits something through probate, or if it's not in a trust, there's a legal issue where a minor is really not allowed to inherit or be distributed assets until they turn 18. And so if you leave everything to your kid or two kids that are 4 and 5 years old, how are the kids going to manage a bank account with $1 million in it? How are the kids who are 4 and 5 years old going to manage a property with tenants in it and deal with those issues? So when that's the case, if you leave it to the kids, then you would then have to file what's called a guardianship with the court. And a guardianship is similar to a probate, but a guardianship is when you have someone that's under the age of 18 years old, or they might be over 18 years old, but they don't have a mental capacity, or they have a very diminished mental capacity and they're unable to make decisions on their behalf. So the guardianship, again, more money, that's thousands and thousands of dollars on attorney's fees, court costs, doctor fees, auditor fees. You have to file an accounting every single year until they turn 18. It's very, very tedious. And if you leave everything to the kids, they can't inherit it. So in order for them to receive those assets, someone would have to file a guardianship with the court, have a legal guardian appointed, which may not necessarily even be a family member. There's a difference between a natural guardian and a legal guardian. Natural guardian might be the parent of a child, whereas the legal guardian is someone that's appointed through a court order in the guardianship case. And so it would not be ideal because then everything is whatever assets the children inherit is now all being controlled by the court. In order for the guardian to move some money out of an account or to sell an asset or to do anything in which the asset is technically the kids, you have to file a petition with the court in the guardianship case, set it for hearing, go in front of the judge, explain to the judge why you need to take out $1,000, where the $1,000 is going to. And it's almost good in a sense to, their job is to preserve, the children's assets and make sure the guardian's not blowing it or using it improperly. But it's extremely tedious, and obviously that's not free. And every time an attorney has to go to court or file documents, you know what that means? attorney's fees, attorney's fees, attorney's fees. So whatever was left to the kids, and they have to do a guardianship for the next 10 or 15 years just to manage those assets, you can only imagine how much money is going to get blown on attorney's fees and court costs just to give the kids what you had initially intended for them. Alternatively, to avoid that, if you had left, if you had put your house or you had designated your trust as a beneficiary on those same accounts, like an IRA or a Roth or a life insurance policy, upon your death, those assets or whatever funds are in those accounts would automatically pour into the trust without having to go through probate, right? And it's very easy to do. And then the language of your trust will say the money's to be held by the successor trustee until my kids turn 18, or the successor trustee can use money that's in the trust from the IRA or the Roth or whatever it is, or life insurance policy. They can use the money only if it's for the discretion of the children for clothing, food, school, aftercare, daily maintenance of the children. And obviously, so the difference between the trust and the guardianship board is that successor trustee doesn't have to go in front of a judge, pay thousands of dollars of attorney's fees every time to make a withdrawal to use money for the benefit of kids. The trustee or the successor trustee has that discretion to use those funds for the benefit of the kids or whoever it is that's the beneficiary at their discretion, and obviously pursuant to whatever is said in the trust. And so the last point, what Sharon mentioned, is that whoever you nominate as your successor trustee, really, really have to trust that person, no pun intended, because you're giving them a lot of power to manage these things on behalf of the trust. And ultimately, they're using their decision making and their best judgment when making decisions of giving money to the kids or deciding to sell a house or to liquidate stocks or whatever it is. So when you do a trust or before you put together a trust, it's important to have a conversation with your significant other, if it's just by yourself, and really determine who it is that you really trust that would carry out your wishes after you've passed away with the trust.
Man, this is great information here. So let me ask you a question here. So, in your experience, once the trust is set up, and let's say, for instance, a family pass away, how does that work when it gets to the point where that trustee have access to that particular trust? Now, what's your role when it comes to that person now being access to that particular trust? Do you play any role into that as far as guiding that particular trustee as far as controlling that trust?
Me as the attorney that prepared the trust,
Mhm.
generally no,
Okay.
unless they consult with me. What I usually do is anytime a client signs a document, I usually save the PDF to my internal system just in case if a family member contacts me in the future, letting me know that someone has passed away that I prepared a will or a trust for. And so I'll keep that PDF copy just to provide if needed. If someone consulted with me and asked, I'd be happy to assist for a fee. But generally, I don't like to get involved with that because ultimately it's like once I prepare the documents, I can amend those documents, I can make changes to those documents in the future, but ultimately, once I prepare everything, it's off to the family. And then the family then has to have those discussions with the successor trustee or the second layer of backup successor trustee and have those conversations with people that they've listed in the trust.
So another thing too, Attorney Borges, what we normally hear a lot on social media, right? It's like trust fund kids in itself. And so I like to to relay that to when it comes to trust fund kids, as far as that once you have your trust set up, now your trust becomes the beneficiary of your life insurance policy. That's what you call a funded trust. The trust now becomes a beneficiary of your 401k account. The trust now becomes a beneficiary of your IRA account. And so when it comes to this here, instead of you designating a specific person as being a beneficiary of your particular asset, now that trust becomes the beneficiary. That's where it becomes where it call fund your trust or trust fund kids in itself here. So let's say, for instance, you got a 401k account. So instead of having a spouse as far as your beneficiary, now you have your trust as that beneficiary. You just pretty much get with your 401k administrator. After attorney board just have set up this particular trust, you now will get with that 401k administrator, and now you make that trust your beneficiary. And once you work with Attorney Borges, like he worked with Leslie and I, it's specific language in there as for setting out who is our trustees, who is our successful trustee, and then now they have to abide by those particular wishes here. Now, one thing about Attorney Borges with his particular expertise, where he was able to guide Leslie and I, was to say, okay, well, let's say, for instance, if one of the kids get on a drug habit or a gambling habit, and you have assets, how do you avoid a child taking advantage of money that you've set in a 401k or IRA account, and this now they have access to your funds, and how do you protect that? In that particular trust, what Attorney Borges have been able to do for Leslie and I to say, with that particular trustee, if that child, if they was get on a drug habit, they have to show themselves approved to where they're off that particular habit. Maybe it went through rehabilitation, to where that particular trustee can now provide those particular funds in your particular trust. So that's why he was saying it's very important. Whoever you set as your trustee or secondary trustee, to make sure that you're responsible enough to be able to trust them in itself here. We're going to open up some questions here for the Let's Win financial community to join in and ask your own specific questions to where you can get off the mute and ask your questions here. But Attorney Borges, how does that work with trust? Maybe if you have it overseas, we have a lot of Caribbean people here, a lot of Hispanic people here in South Florida. If they was to set up a trust here in Florida, how does that work if they have assets overseas?
If there's assets overseas in a different country or outside of Florida, I can't really advise on that. And so the law in the different state outside of Florida or in the country of where the assets are located, that would preside. And I'm only authorized to give legal advice for anything in Florida. Now, I can give you a different example is that if someone has family overseas, so if you have property that's in Florida, and let's say someone leaves it to the benefit of someone that lives in England, that's okay. You know, even just because they don't live in the state of Florida, and if they live in a different state or if they live in a different country, that's okay. You can still designate that person as a beneficiary of the trust with respect to Florida assets. And you can also nominate that person to act as a trustee. It might not be so convenient because if you need to call someone and they're in a different time zone in a different country and maybe they have to sign legal documents, it may not be as ideal if you have someone in England as opposed to Florida, for example. But you do have freedom to do that. And sure, when there was one point I did want to mention, but I didn't want to interrupt you. The biggest difference between having someone designated as a beneficiary on your life insurance policy, for example, versus a trust is, let's say in my example, if I listed Sherwin as my beneficiary on my life insurance policy, when I die, whatever that policy is worth, Sherwin can get full access to it, and there's no restrictions. So if I have $1 million policy and I die, Sherwin gets a check for $1 million and can do whatever he wants with that $1 million. Whereas if I designated my trust as the beneficiary on the life insurance policy, the $1 million will then transfer into the trust, and then the language of the trust would dictate how Sherwin's going to receive that $1 million from the life insurance policy. So I could put something in there that says any money that's received by the trust from my life insurance policy that's being distributed to Sherwin is only to be distributed where Sherwin receives no more than $2,000 a year for every year until the money runs out. And so that's one of the pros and cons. Whereas if you do have a trust as a beneficiary, it gives you more control of the asset after you've passed away. And now, if you have children that are over 18, or your beneficiaries, one of your parents or a sibling, and you're okay with them getting full access to the asset upon your death, you can just designate them as your beneficiary on a bank account or a life insurance policy. That's totally okay. And by designating someone or multiple people as a beneficiary on those accounts allows you to skip the probate process for that asset. So it really comes down to your preference. And I know everyone's situation is unique and different. The rule of thumb is if you have kids under 18, you should always designate the trust as the beneficiary on all of your assets, essentially because the trust is going to protect and restrict and control and hold those assets until the kids turn 18 or 21 or 25 or whatever it is that you want to.
So that's very good information here. So kind of want to open it up here to the community here. Alexis asked a very, very great question here. There's two things that happens when you buy a house, all right? Yeah, you get a loan for a bank, but also too, you also become part of the deed. So if a couple's to buy a house, uh, and so their names become both on the deed, and also too both of their names become part of the loan. But Alexis asks, how does it work if you're on the deed of a house, not the loan, but there's a trust in place?
The
How does
loan
that?
doesn't, yeah, the loan doesn't affect anything. So it doesn't really matter for trust purposes and for probate purposes. It doesn't matter who signed the loan. That's just a matter of financing. What's important is who's on title and how they're on title on the deed. So in this case, if you had, let's say, husband and wife are both on title as husband and wife, and let's just say the wife is the one that signed the note and mortgage, and the husband didn't, or maybe the husband was forced to sign the mortgage because they're married and it's their homestead, but he's not on the note, so he doesn't have any financial obligation. That's ultimately the whoever signed the note or the mortgage or is on the loan doesn't affect anything, except for the obligation to pay the lender.
Got it. Got it. So, Attorney Borges, I know this probably might be a preliminary question. It depends on each person situation, and you don't necessarily have to answer this like into detail. But as we talk about trust, right? Well, I think one of the main fears as far as what probably prohibits people from setting up a trust would be one, they don't understand and really know what it is, but tonight they get a better understanding. I think the second aspect of it is the cost that's associated with the loan in itself here. So like from a general scale, and I know you have your own set particular costs here, right? But what's a general scale would you say setting up a trust? How much is that generally cost?
I'll give you the attorney answer. It all depends, right?
Mhm.
So anytime I prepare a trust, it's very rare that I just prepare a trust for a client. And I think there's actually some here I prepared for. I think Julie's here, but I also recommend doing a living will. And then it also depends. Am I doing it for husband and wife? Am I just doing it for one person? If I'm doing a living will, there's usually two living wills. I'll also recommend doing a power of attorney, which is not required, but it's recommended. And then it also depends on how many properties the person owns. If they have multiple properties, I have to prepare a quitclaim deed for each property and then transfer title from the property into the trust. And so that's additional work, additional cost I have to pay to the county to record it. But if I had to give you just a very general example, and when I was younger and I did these things, I would always give out quotes and I regretted it every time because someone would say, "Oh yeah, it's easy. We're leaving everything to one person," and then it turns out there's 100 assets. I want my gold ring to go to my aunt over in Canada. I want my chain to go here, this and that. And then it was, I ended up losing money on how much time I had to do it. But if you have let's say for one person, if it's just a basic trust and no more than one property, I don't think it should exceed anywhere above $2,000
Got it.
ballpark. I can tell you that and again, I can't speak for what another attorney is going to charge. I have no control over that. If you have a husband and wife, and let's just say it's one, maybe two properties, and they do a revocable trust and maybe a land trust for the secondary property, living wills and the power of attorney, then that could be anywhere from maybe 3 to 35 or even $4,000 ballpark. Again, it all depends. But I can tell you, generally speaking, whatever you spend to do a trust and everything else is going to be way cheaper than whatever your estate or your children or whoever it is that your heirs or beneficiaries are going to have to pay down the line to do the probate.
Got it. That's very, very good. So let me ask you this question here. If there is say a young parent on here that has a house, want to set up a trust for a kid, and let's say for instance they may have not have say $2,000 here, right? Is there any flexibility from your particular firm where you're able to work with them, maybe two payments or multiple payments to set up a trust?
Yes. Yeah, I'm open to that. I usually don't ask for everything up front. Sometimes I'll do half up front, half on the back end. But everyone's situation is different. So depending on how much work I'm doing and whatever it is they tell me they need to do, I'm kind of flexible on that.
Got
I'm
it.
not going to say, hey, I need everything up front or else I
Yeah.
I don't work. I try to work whatever's reasonable.
Now, I will warn you here, Attorney Borges, you can probably within the next week, as early as tomorrow, you can get inundated with a lot of people from this community that's contacting you. So we'll be able to put your contact information towards the end of the session here. But we just got a very, very great question here as we talk about trust here, right? There is two different type of trust, at least from my knowledge. We have irrevocable and irrevocable trust. Can you tell us the difference between what's the difference between a revocable trust and an irrevocable trust, and what's the pros and the cons?
Yes. So you're correct. The two different types are revocable and irrevocable. Sometimes you'll have people pronounce it as revocable and irrevocable. To me, it takes too much energy to say that. So I just say revocable and irrevocable, and it's just easier to understand. So when you think revocable, you're thinking of the word revoke, right? When you revoke something, you're taking something back or you're making a change to it. Whereas irrevocable, you're almost saying you can't change, you can't revoke that document. So the difference between the two different types of trust is with revocable trust, you can actually terminate the trust and you can make any amendments or any changes to that trust at any time without penalty or anything like that. With an irrevocable trust, you can kind of tell by the name of it, you cannot make any changes to that trust at any time. In order to make a change to the irrevocable trust, the trustee or the beneficiaries or whoever it is that's seeking to make a change to the trust would have to file some type of action with the court and essentially get a court order from a judge authorizing the parties to make a change to the irrevocable trust. Most of the time, the judge will allow it as long as it's something reasonable and doesn't go against the main terms of the irrevocable trust. But those are essentially the two different differences between the trust. And I see that there's also a question that says, what happens if you need to make changes throughout the years once the trust is done? So if you have a revocable trust, like I said, you can make as many changes as you want at any time. And the procedure for doing that is you would execute what's called an amendment to the trust. And an amendment to the trust is almost like an addendum to a contract where you essentially say, I executed a trust on February 11, 2025. It's 10 pages long. However, I'm only changing paragraph 2 on page 2, where I had left Sherwin as my sole beneficiary on my trust. However, Sherwin didn't invite me to speak on his estate planning seminars the next year, so we had a falling out. So now I want Sherwin's parents, Clifton and Sonja, to be my beneficiaries. So in that case, in the amendment, it says everything stays the same in the trust. However, we're just changing this little part. That document also has to be signed by the trustee, and it also has to have two witnesses and a notary as well.
Awesome, awesome. Great, great information here. So, let's win family here. We're going to open it up here for the next maybe 10, 15 minutes here. We're going to go to 9 o'clock. And you can unmute and ask your questions here over to Attorney Borges.
Hello, attorney. Thank you for taking the time out to share some knowledge with us. We appreciate you and value you once again for coming another year. I have a question. I wanted to know if you do asset protection.
Yes.
And good. And I wanted to know as far as, can you enlighten us a little bit on the when the recording an LLC for businesses, a Florida LLC versus now I'm hearing Wyoming, a Delaware LLC to remove your name from public record.
Yes,
Can
that's a
you
good question.
shed some light on that a little bit, please?
Yes. So technically, I'm not authorized to speak on anything outside of Florida, but I do have
Oh,
experience with Wyoming LLCs.
got
I work with a lot of real estate investors, and they love Wyoming to do LLC for more so privacy and protection. So what I can tell you, and this is not a legal opinion, I'm just throwing out my disclaimer there because I can't give law or advice of law in a different state. But what my clients, why they like Wyoming LLCs as opposed to Florida LLCs is if you try to look up information about a Wyoming LLC, all you're going to really be able to find is an address or an address for the principal place of business, but you're not going to see who the actual owner of the entity is. It's very protected and it offers the business owner a lot of privacy, and it's very inconvenient and time consuming to try to locate who actually owns the business. And so a lot of clients that I have love opening Wyoming LLCs for privacy purposes and then asset protection. And it's almost like a deterrent where if you have to sue someone that's a Wyoming LLC and you're no stranger to litigation and real estate, and I see that the opposing party is a Wyoming LLC, the first thing I'll tell my client is the guy that's on the other side of this with the Wyoming LLC knows what he's doing. It's not going to be easy to get money from him. He's probably got all of his assets protected, and you're going to have to spend a lot of money with me in order to get something and to fight this guy because he knows what he's doing. The difference between that and a Florida LLC, anyone in general can go to www.sunbiz.org. That's sunbiz.org. And you can look up any entity that's formed in Florida, and you can see the principal place of business. You can see the registered agent's name, the registered agent's address. You can see whether it's a member-run company or managers, and then you'll see who the members and who the managers are of the company, depending on the entity structure. You see their address. If they make any amendments to the company, all of that is available for public record, and anyone can see it for free. So if you have nothing to hide, it's not a big deal. You can definitely do that. But if you're like me and you prefer a little more privacy and don't want someone looking up all your stuff online, then you can always do a Wyoming LLC, or you can, if you're looking to protect property, and this is kind of a different direction, you can put your property into a land trust. And the reason a land trust is different than a traditional revocable trust, a land trust is used just as a holding structure to hold a property. And obviously by the property being in a land trust, it doesn't have to go through probate. And the benefit of a land trust versus an LLC is with a land trust, you just prepare a one-time fee to an attorney to prepare it. You don't need to be an attorney to prepare the land trust, although I recommend it. And with the land trust, it's never recorded in the official records of the county. So what that means is if you have property that's owned by a land trust, no one can see who the beneficiary is, what the land trust says, if there's been any amendments to the land trust. All they're going to see is a quitclaim deed, which is transferring a title from the property from whoever the prior owner was to the trustee of the land trust. And the reason I like the land trust is, again, you get more privacy as opposed to an LLC where no one can look up your info, and then it's cheaper in the long run. So in order to keep an LLC open, you have to pay an annual fee to the state of Florida, which is like $180 or $200, somewhere in that range. But if you're planning on doing business for long term and you're looking at this over 20 years, let's say 20 times 200, that's $4,000 you're paying to the state of Florida just to keep your LLC open, where maybe you spend a couple $100, you open up a land trust and you keep the property in the land trust and you get more privacy. So that's something else I do with clients when they have investment properties. I put that in the land trust versus putting it in an LLC.
Thank you very much.
No problem.
Awesome information here. Unmute, guys, if you have questions. We'll go to 9 o'clock here.
Giovanni, I have a question.
Hey, Donna, long time no talk.
We talked this morning.
Yes.
Yeah, guys, Giovanni did my trust a couple of years ago, and he was awesome with every penny. So I have a question. Piggybacking on a question I had this morning. Can my daughter, two questions. Can my daughter put her house in my trust, her other assets?
Yes, she can.
She can, okay. And what is the difference in a quitclaim deed and a ladybird deed? I did a ladybird deed in my trust. You did that for me, but I heard about a quitclaim deed. So I want to know what's the difference in those two.
Right. A quitclaim deed is just a transfer of title from one owner to the other.
Mm-hmm.
With a quitclaim deed versus like a warranty deed, a quitclaim deed is just the person that's transferring title, who's the grantor. They're not making any promises or warranties about the quality of title or any title defects or liens on the property. So I could technically sign a quitclaim deed to the Brooklyn Bridge, which I don't own or have any interest to, and sign it to you. And I wouldn't get in trouble because the quitclaim deed just says whatever I got, whether I have anything or I don't have anything, I'm giving to you. I make no promises, no warranties, no nothing. So a quitclaim deed is not really ideal because the person's not really guaranteeing anything. But for example, if you're just transferring title of your main property to your trust, a quitclaim deed is fine because we know that you're the owner and you're just moving it from your individual name to your trust. And then what was the second question? Oh, the ladybird deed?
Yeah.
So the ladybird deed is it's essentially what's called a life estate deed. So for example, I think what you did, well, I'll use me as an example. I actually have a life estate deed on my primary residence. So when you execute a life estate deed, you're essentially transferring title to the property from the owner back to the owner, but for the duration of their life. And there's language in the ladybird deed that says upon the grantor's death or upon the person that owns the property's death, the property automatically is transferred to, and then you would put whoever it is that the beneficiaries are. When it comes to title purposes on a ladybird deed, it's called remainder men. Whoever came up with the terminology was not, they didn't come up with that term recently because it doesn't have to include men. But the remainder men are essentially like another term for beneficiaries. So it's someone or multiple people that would receive the property after the owner has died. And the benefit of doing the ladybird deed is that that's also an exception to probate. The house doesn't have to go through probate if you have a ladybird deed in existence before you pass away.
But if the house is in a trust, it also doesn't have to go through probate.
Correct. So it
Okay.
depends on your preference. So for me, on my house, I left everything to my mom and my sister, who are both over 18. I have a trust for something else and some other stuff, but just for my homestead property, I just did a ladybird deed a long time ago, and I just have it so that I was going out of town or something. I rushed to do it. So if I passed away, title automatically go to my primary house, goes to them without the need of probate.
Okay.
And so, Giovanni, that's a very great question because one of our clients here, she is single, not married. She has an adult son. What she was able to do was set up a life estate deed. So her house automatically transferred to her son upon her death. And any of her assets, like her 401k, savings account, IRA, she has a son listed as a beneficiary. And those assets will pass to her son through those investment accounts, bank accounts, but then with her property, by setting up a life estate deed, then that property would avoid probate.
Okay.
I always tell people this here: if you got young kids, life estate deed is not what you want to do. Set up a trust is, but a life estate deed, like in that particular scenario, it kind of makes sense because if you only really have one child, a life estate deed is a little. If you could correct me if I'm wrong, it's a little bit cheaper than
Way cheap.
setting up a
Couple
trust.
$100. Couple
Yeah.
$100 is, and again, you don't, again, the trust is really if you have kids that are under 18, or if you want to restrict how your assets are distributed after your death. So that example that Sherwin gave, if we have mom who's just leaving everything to the son who's over 18, and she's okay with him getting everything automatically upon her death, then yeah, just do a life estate deed for the property, which essentially he gets it upon her death, so the house doesn't have to go through probate. And then any bank accounts or life insurance policies or any other assets, she can just designate her son as the beneficiary and everything goes to him upon her death without having to go through probate. And that's much cheaper. And this is something that's important too that we didn't cover. In order to designate a beneficiary on your accounts for your bank account, life insurance policy, 401k, retirement, anything like that, there's no fee. There should be no fee to do that. So if you call the bank or your companies, they usually send you a form. You fill it out, you designate who your beneficiary is, their address and the relationship to you. There should not be a fee associated with that. So that's a free thing that you can do after tonight without, you don't have to pay an attorney or anything like that to designate a beneficiary. By doing that, that asset doesn't have to go through probate. So that one designation, I did a probate maybe 4 or 5 years ago, and I think the life insurance policy was over $5 or $6 million. And the guy, I think when he passed away, he had a will, and he left everything to I think like one of his friends. So you guys can see the problem, right? Because if he would have went to the estate planning seminar tonight, he would have said, "Man, what am I doing? $6 million? I could have just designated my friend as the beneficiary of my policy, and he would have got it after I passed away." But instead, I had to do a probate. I had to open the door with an asset of $5 million, probably 10 or 12 creditors that filed claims against the estate. I had to litigate those and try to settle, and they were going after the life insurance policy. Probate took a year to do, and in Florida, there's a statute that allows attorneys, and the value of the estate exceeds a certain amount, and I think it's usually the first $1 million, the attorneys can charge a percentage of the value of the estate as their attorney fee. So I'm not here to brag about how much money I made, but if you guys do the math, whatever 3% or 5% is of $5 or $6 million is, you can imagine how much his friend had to pay me to handle all this and then plus deal with the creditors. Whereas all he had to do was just designate a beneficiary on that account, wouldn't have had to spend a penny, and his friend would have got everything instantly upon his death how he meant it to be.
Awesome. All right, guys.
I have a question. Last question. I heard, I'm not sure, correct me if I'm wrong, that they are reducing the cap, the amount of tax, I mean, they raising the amount of tax that you have to pay on a trust. if the net worth of the trust is over a certain amount?
That's when we need Sherwin's wife here to give you the tax advice. I can't give you advice on the taxes for example.
Okay, so that's
CPAs
a
are
fact.
usually CPAs are better aligned to give you tax advice on these things. What I can tell you, my limited capacity is that if you move a property into a trust, for example, that's not going to generally change the property taxes. If you have a homestead exemption on your primary property and you move it into a revocable trust, you're not going to lose your homestead exemption. It shouldn't affect your mortgage really, as long as you continue to make your payments, and it won't affect your property taxes for the most part. That's all
No,
I can tell you on the taxes. Anything on that, you're gonna have to call Sherwin's wife and ask the expert.
okay.
Awesome.
That was something else that I mentioned. But since you touched that too, my last question is on the homestead. When you switch the property, let's say you have one property, that's your home. When you switch that property to a trust, is it can that affect your homestead right on that property with the county?
No, as long as you continue to live in the property as your primary residence.
So pretty much with Broward County, you just have to show proof that you still live in that property is still your primary residence for
You
them
have
to.
to you have to apply with the county for the homestead exemption. You can apply for that. I would recommend you do that as soon as you obtain ownership interest in the property. And there's an application that you would do to get the tax credit, which is essential. And that's usually pretty easy to do. But once you move it into revocable trust, the county might reach out and ask for a copy of the trust just to verify the language is correct. That won't affect your homestead exemption. If
Okay,
you
yeah, that
move
was
homestead property into an LLC or an entity, that will wipe away your homestead exemption because homestead
that.
does apply to entities. So it
Okay,
has to be in a revocable trust. You could
sure.
put it in land trust, but I recommend doing the revocable trust for your primary residence. But never, ever, ever put your homestead property in an LLC or an entity. That'll wipe away your homestead exemption. Your taxes are going to skyrocket. It'll affect your portability, and you're going to get. I was going to use a bad word. You'd be in a lot of trouble.
Okay, yeah,
So,
that's
yeah, yeah.
especially right now. I know they are pretty much knocking on doors. They going after homeowners for stuff like that too. As far as the county, they being very aggressive, collecting, removing homestead, collecting taxes.
Oh yeah.
So I had a situation like that too. That's why I wanted to confirm. So you can put on an LLC, but the trust is what gets you what you need.
Yeah.
So it has
Yes.
to be the trust. Beautiful.
So
Thank you.
Attorney Borges, I would say Zamora here, who's asking these questions, if anybody on this call tonight, or maybe is watching, him and I have several conversations. If anybody need a trust in place, and I'm gonna challenge Zamora on this right here, it would be him. He's a prime example of multiple real estate properties with young kids. And so, Zamora, I'm gonna challenge you here, man. That's going to be our next quarter goal to contact Attorney Borges, man. As a young guy like you are, that's killing it in the financial world, to get the trust in place here. So,
I knew he was the real deal when he was asking about the Wyoming LLC.
yeah, yeah. Now, and Attorney Borges, I'm not talking 3 or 4 properties either. I'm talking about that times 5. So he is a prime candidate that needs this trust in place.
I got a court hearing tomorrow. Let me tell the judge I can't make it, and you call me tomorrow morning.
Absolutely. All right. So let's see here. I did see a question here in the chat from Jody here. If you have a premarital asset and in the process of divorce, would you recommend placing the house in the trust? Also, what happens if you do not choose a beneficiary for the trust?
Sure. There was one more question before that from DM McCarty, and it's a good
Mhm.
question. It says, do most couples do a revocable or irrevocable trust? Most people in general that I prepare trust for are almost always revocable. You want the ability to make any changes to that trust at any time without having to go through court. So you might ask, why would anyone ever do an irrevocable trust? It's so inconvenient, you can't make changes. An example would be, let's say, Elon Musk, who's the richest man in the world, right? A lot of his family members probably want to see him die so that they can step into some kind of wealth. It's almost like that movie, Mr. Deeds, where Adam Sandler walks into like $40 billion. So if you have a situation where perhaps you have maybe, let's say, a parent that has a large estate, lots of assets, lots of money, and you may have some family members or suspect that there might be some foul play, or they may try to take advantage of a family member that has dementia or is old or doesn't have the capacity to make their decisions. An irrevocable trust is good because you can move their assets into that trust. And should someone try to take advantage of that person or the owner that doesn't have the mental capacity or is going to be taken advantage of due to their age, the irrevocable trust is perfect for an example like that because no changes can be made to what the trust says or the assets that are in the irrevocable trust. So a situation like that would be beneficial for an irrevocable trust, but it's very rare where I do things like that. I think I only had one situation where I had a couple come in and the guy was maybe 85 or 88 years old, could barely stand up, and his wife looked like she was my age, and had a Louis Vuitton purse, the Gucci shoes, a ring that looked like it was worth more than my entire net worth, and I kind of had a feeling what was going on. So every now and then you see stuff like that, and maybe an irrevocable trust would be good for a situation like that. But 95% of the time, I always tell clients, revocable trust is the way to go, whether you're single or in a relationship. With respect to the next question, if you have a premarital asset and in the process of a divorce, would you recommend placing the house in a trust? Also, what happens if you don't choose? Okay, so let's stick with that first question. So marital law is a little tricky. The judge is going to look at things if a divorce happens. The judge is going to ask questions about whether the other spouse lives in the property. Are there children? Do the children live in the property? Who's the primary caretaker? How long have you lived in the house? Who's responsible for doing certain responsibilities? And generally, if it's a premarital asset and there hasn't been commingling of marital assets or marital funds, the asset can usually be treated as a premarital asset and wouldn't be subject to equitable distribution, which is a fancy way of saying that when you're married and you have joint assets, the court can enter an order basically distributing the assets or part of the assets or money to a husband or to a wife and so forth, and that can get a little messy. So that's a tough hypothetical because there's a lot of factors that can affect that. But what I can tell you, just from this is kind of not related to this, but for marital stuff, if you're worried about a divorce possibly coming, or if you're trying to be cautious with your spouse, when you commingle funds, for example, if you both share a bank account, you both make deposits and withdrawals from that account, that's going to be considered a marital asset. So if you guys were to get divorced, the judge would have the authority to essentially consider that an asset, a marital asset, to where the judge can make distributions and rule about equitable distribution. Whereas if you have a separate bank account where there's no commingling of funds and it's just your account, you keep it off to the side, your spouse doesn't contribute to it or doesn't have access to it, that asset may not be subject to equitable distribution in the divorce itself. But divorce is it's a tricky one because everything I said could be true and the judge might rule completely in a different favor. So prenups are great. I know it's kind of frowned upon in today's society, but I think prenups are really a great thing for most couples if they're fair for both sides.
All right, guys. So we'll take two more questions and then we'll be done. So anybody else, any more questions?
I see one here. I think this is also from DM McCarty.
He likes. Hello.
Yeah, go ahead, man.
Chihuahua.
Okay. Well, I got him on mute here.
I do see a question here from DM McCarty. It says, can you do a trust for individuals in Georgia since you practice law in Florida? The answer would be no. Georgia might have different law when it comes to trust. Hypothetically speaking, do I think there's a major difference? If I were to draft you a trust, would I think it would be sufficient in other states? Yes, but I'm not authorized to say that. And I have to give you the politically correct answer that you have to consult with an estate planning attorney in that state that's licensed to practice law there.
Yeah. So, Attorney Borges, that's a very great question that particular individual asked, because they have several real estate properties as well that we're going to be working with them on this year for that. And it's a single person as well. So we want to make sure that in the event that that particular person passes away, those assets are protected based on that individual's personal wishes in itself here. So Another great person that could well do for a trust in itself here. Go ahead. She has another question here. Go ahead.
Sure.
Hi, I'm Sherwin. This is actually Dewan. So I have a question. Since I have a property in Georgia and I have a couple properties in Nebraska, will I have to consult with two different attorneys, one in Georgia and one in Nebraska?
Yes.
Okay.
Yeah, because ultimately, if you're trying to move a property into a trust, you're going to have to execute some type of deed that conforms with the law of the state in which the property is located at.
Okay, so do you have any recommendations for Georgia lawyers or
I
Nebraska?
don't know anyone in Georgia and Nebraska. I do know an attorney that's licensed to practice in Georgia, but he doesn't do he just does slip and fall.
Okay, thanks.
But here's a recommendation I would give you guys. I know sometimes it's hard to find a lawyer if you're just kind of going on a Google search. Google reviews aren't always accurate. Sometimes they are, but like any kind of vendor, what I like to do, just generally speaking, and even sometimes with other attorneys, is maybe just type in, estate planning attorney, Georgia, or the county of wherever that's at, and then look at their Google reviews, and then you can tell when reviews are fake or when they're actually authentic, and maybe just try to go off the Google reviews and see if you can find one where it seems like the reviews are sincere and honest, and maybe that's a good direction. And don't be scared to call multiple attorneys and kind of maybe give them even pay for a quick consultation, and then just have them give you a couple quotes. And ultimately, if someone looks like they can perform a good service and you can save a lot of money, then it's something to take into consideration. But I would always warn, especially in the legal field, cheaper isn't always better. There's so many attorneys I run into that do probates improperly, or I'll have clients refer to me that have no clue what they're doing and charged 5 or 10 times more than what I would have charged and have no clue what they're doing. So just make sure you exercise your due diligence when picking an attorney or someone to help you, because it's obviously an important decision.
Okay, thank you.
No problem.
So Attorney Borges here. Zanella, you have a question? I see you on the unmute.
Yes, I do. Hi. I do have a question. So my husband and I, we do want to do a trust, and we have kids that are older, 24, 25, and 26, and we have kids that are younger, 14 and 12. So if we create a trust, so do we need to have a trustee also on top of that? Because our older kids, I don't think they will be capable of taking care of the younger kids. So do we need to have the older kids as beneficiary and then have the trustee that will take care of the younger kids? Is that recommended, or?
I think you're confusing trustee with the guardian. So you can actually appoint someone in your trust to be the guardian of the child.
A guardian? Oh, okay.
Right. So the guardian could, generally speaking, courts prefer if it's a closer relation, the better. So if it's another parent, if it's a sibling, generally speaking, and in order to be a guardian, you can't be a convicted felon or have any felonies. Anytime you would have a guardian appointed through the court, they do an extensive background check to look for any. They do a credit check, actually, believe it or not. They do criminal check. If you're a felon, that automatically removes you from qualification. But you can list who it is that, if you and your husband have a preference for who it is that you want to be the guardian of the minor children, should both of you pass before they turn 18, you can also list that in the trust as well. And it doesn't have
Okay.
to be your other kids. If you want to, you can. If you want to accommodate more than one guardian, you can do that as well. And then in terms of, to answer your second part of your question, whoever you want to be the beneficiaries or the trustee of the trust, you can pick anybody. It's kind of, if you like one kid more than the other and you want to do 90% to your favorite kid, 10% to your least favorite kid, you can do that. You're actually allowed to do that under law. It might cause some family drama. I wouldn't recommend it.
Yes.
You're free to do as you choose.
Yes. But then what happened? Okay, if we do a trust and then we transfer our home to the trust, and then what happened if we passed away? What happened to the loan?
The loan still has to be paid. So the successor trustee or whoever's in charge of managing the trust would be responsible for continuing to make the loan payments, because the trust then becomes the new owner of the property. The lender really doesn't care who's paying or where the money comes from, as long as they get paid. They only start asking questions and get concerned when the money stops, just like most people in life.
Okay. I see. So also we have like a LLC. So can we add that with the house, or we'll need a different trust with that for the
Great question.
LLC?
Great question. So with an LLC, Mr. Zamora will probably appreciate this answer. You can do what's called an operating agreement. So an operating agreement is pretty much like a will or a trust, but for a business and for an entity. And so in the operating agreement, you can put all your business procedures. If it's a really big corporation, you can put voting rights and meetings and agendas and all that. But for most people that just have their own LLC for liability purposes, you don't really need to have that. But in the operating agreement, what I usually put is that Sherwin and Giovanni are joint owners 50-50. Should Sherwin die, or excuse me, should Giovanni pass away, his 50% interest.
Mhm.
Sounds like a good TV show in the background.
Yeah, I
If
muted. Yeah.
Giovanni passes away, his 50% interest in the company should go to his wife, Jane Smith, or his child. Or I've even had some clients get creative where they'll put language in there that says the other member of the LLC has the option of purchasing my or buying out my estate's interest for a certain price. So you can get really creative, but I recommend doing an operating agreement for the LLC, which essentially says who takes over the business and how it's to be controlled if the owners pass away.
Very great information, Attorney Borges. I want to give you the opportunity, if you can, if you could put your information in the chat, and I'm going to encourage the Less Win financial community, once Attorney Borges put his information in the chat, I'm going to ask that you guys screenshot this here and be able to reach out to him. There's not a lot of opportunities where you have an estate planning attorney to be able to help you be able to manage your own estate plan and put that into place and secure. Here's the key word, guys. Tonight is to secure your family financial legacy here. So when I think about and I look at people on this call here tonight, I look at Charles here that's married with a young family. He needs a trust here. I look at Miss Ann here who set up a life estate deed with the single son. She has a trust in place. I look at Paris with a young family. She needs a trust here. I look at Miss Greta from Georgia, just retired. She needs a trust. So many other people that's on this call here tonight, I challenge you. If in 2025, if you do not have an estate plan, if you only have a will in place, as Attorney Borges mentioned tonight, your assets, your estate is going to go to probate court, and it's going to cost time and it's going to cost money. So I challenge you in 2025, it's okay to go on a vacation. It's okay to do whatever you wish, but it's not okay if you don't put an estate plan in place and set up a trust, because in the event, there's two things that happens in life. There's taxes and there's death that's going to happen. And so you're going to pass away. And if you don't have an estate plan, specifically a trust in place, then your assets, your family are going to be fighting over your particular assets. And that's the last thing that you want to happen.
Hello?
So tonight we've been able to have a personal estate planning attorney come over to us and give us this valuable information. So I want you guys to take this information, and as we talk about here in the Less Win financial community, I want you to execute. Not just hear it, not just apply it, but execute it. Contact Attorney Borges, especially if you're in the state of Florida, and get your trust done. Again, it may be a little costly, but it's going to give you a little peace of mind at night. And Attorney Borges has mentioned to us that he's flexible as well. Necessarily not to have all the costs up front, but he's also flexible to work here with you. So my goal here is for each and every person here to have some type of estate plan established before the end of the year. Attorney Borges, any final comments here before we close out tonight?
I just realized that I didn't say anything about my background or intro or anything when I started. I completely skipped it. So, Julie, if you can hear me, I actually I still have some stuff to work on with Julie. I actually opened my own law firm on January 1st of this year, so I do have updated contact info, which I put here in the chat. So I don't know if Julie can hear me, but I put my new info in there. So if you send any emails to my prior address, I didn't get anything, but I'll just give you guys a quick background because Sherwin gave me great words, but I know I look young and I still can't grow a beard after 33 years. And I kind of gave up on that. It's not happening, but I wanted to give you guys just a quick background so you have a little trust with me when you're doing your trust, no pun intended. I graduated from UCF in 2000, man, what year is that? In 2013, I graduated from UCF with a Bachelor of Science in Legal Studies, a minor in business administration, a certificate in public and professional writing. I went to law school at Southeastern University. I graduated pretty close to the top of the class. I was named to the dean's list a couple of times. I received a book award for getting the highest grade in some of my classes. Prior to even going to law school, I was a paralegal for 4 years at a big real estate litigation firm where I learned a lot of the stuff I know now. I learned as a paralegal before I even went to law school. When I was in law school, I continued to be a law clerk all 3 years. So I was in school full time, but I also worked 20 to 30 hours a week just to make a little bit of money, but also to gain real life experience. And as of this September, I would have been an attorney for about 6 years. So I know I look a little young, but yeah, I've really been doing this since 2010. Not as an attorney, but in terms of having real life experience, drafting these documents, being around real estate, probate, title, and things of that nature. So, like I said, I just opened up my own firm. So if for some reason, if you guys can't get a hold of me, just send me another email. I have 2 assistants now. I hired an extra one to help. But I'd love to work with you guys. And as always, thank you, Sherman, excuse me, for having me. And hopefully I didn't put anyone to sleep and you guys found this somewhat a little exciting and you learned something tonight.
Absolutely. Attorney Borges, I want to thank you for coming to us. I love tonight because it's scenario based and it's applicable because we can actually apply it to our lives based on what's happened to us in the previously situations where we learned stuff from some other family members. Just had a guy that's a non-Let's Win financial member. He was telling us that, hey, look, my dad passed last year, bladder cancer. I'm currently going through probate now just to get access to his house. So this is the things that we set up tonight to make sure that you come, educate, inform, and empower us on this information so we can learn on some past mistakes and not necessarily have to go through some of the troubles that what our current family members are facing. So again, Let's Win family, let's take advantage of this information. Reach out to Attorney Borges. He's put his contact information in the chat. So let's screenshot that. Let's inundate him. He just started his brand new business. So he's been a blessing to my family, my own personal family, but not just to my family. Attorney Borges, he's very near dear to me because he's generational. I don't think he understands that. When I say generational, because he set up my parents' trust as well. When my parents own multiple assets, and so my family, my siblings don't necessarily have to fight over those particular assets that my parents worked so hard for to set up, and now we can just continue to be able to pass it down from one generation to the next because of his particular expertise and empowerment and what he's instilled in my own personal family. So, Attorney Borges, thank you again for coming to the Let's Win financial community. And so we're so grateful for this information that you share here with us. This is also recorded. So we will have this on the Let's Win Financial YouTube page. So if you got on late, you can always come back and look at the replay again and get some of this valuable information that was shared tonight. So as always, guys, be well,
Sharon,
be blessed. I'm sorry,
Sharon.
Angie, go ahead.
Hi, it's Angie. Sorry, I had one quick question before,
Really quick, make it really
disconnect.
quick.
Yeah, I wanted to ask one question. Like when he does produce the trust, does he do the title and also power of attorney along, with the trust for the customer?
Yes.
Okay.
And there's going to be separate fees. So if I have to do a quitclaim deed to move a property into a trust or a power of attorney or living will, usually each document has a fee associated with it. So it really depends on what it is that you want to do. But I would do all that in one.
Okay, thank you.
Absolutely, absolutely. So with that, Angie, part of our trust, we also have a power of attorney and a healthcare surrogate. So in the event my parents get incapacitated, within that trust is set to who we want to make those special directions on a healthcare surrogate in the event the parents are incapacitated or if they need to pay their bills, that we have the power of attorney as well. So that's also, guys, part of the trust that's established here as well. So great question there, Angie, in itself. But any more questions, guys, feel free to reach out to Attorney Borges. And guys, make this a priority for 2025. Do not let this year go by without having a estate plan in place because there's been too many examples of what we've seen in the past, especially celebrities. They got plenty of money where they only spend a few dollars to get based on compare what they make in order to avoid some of the troubles of what they're going through and what their family members are going through themselves. So All right, guys. Thank you guys for joining in tonight. Be well, be blessed, and as always, let's continue to win. Thank you guys for joining in. Thank you, Attorney
Thank
Borges.
you.
All right.
Thank you guys. And you guys, and last thing is you're gonna sleep a lot better at night when you know that you have all of your assets taken care of in order, your family's protected, your legacy is protected that you worked hard for, and everything is gonna go to the people that you want it to go to without having to go through court, without your family having to spend thousands of dollars on attorney's fees. I'm telling you, the peace of mind that you'll get once everything is locked in and settled is invaluable.
Awesome. Awesome.
All right.
Awesome. Thanks again, Attorney.
All right.
Good night.
Thank you,
Bye, guys.
guys. All right.